Hello, my dearest friends. Svetlana Shlapak, the founder of ukvisasuccess.com is here. If you are an international or a family member of an international, you are probably quite naturally concerned about your present and future rights to remain in the UK. I have been practicing UK immigration law for over a decade now and discovered that a lot of internationals and their family members have only a very vague idea about their immigration rights in the UK. And to rectify this, I decided to create this special frequently asked show where I'll be answering various questions and clarifying different aspects of EU law. If you find these videos useful, please do like them, subscribe to my channel and share them with those who may benefit from them. And here is your next question. Retain right of residence for former spouses of civil partners of EU nationals after their divorce, category number 4. In my previous videos, I've given you an overview of all 4 major categories of people who can claim that they have retained their right of residence in the UK. I've explained and have given you examples for categories number 1, 2, and 3. Today's video is about case scenario number 4. This video is for former spouses and civil partners of EU nationals who have retained their right of residence in the UK, despite the fact that they are no longer with their EU national spouse. This video is also for those family members of EU nationals who became victims of domestic violence. Case scenario number 4. It may seem complex to you at first, but I guarantee that you will get it after I give you a couple of examples. Case scenario number 4 is for non-EU national spouses or civil partners where their relationship ended. This is only possible where their marriage has been officially terminated. So if a non-EU national only separates from his EU national spouse, his or her right will still depend on their EU national spouse. In this case, the non-EU national separated from his spouse will only lose his or her right to remain in the UK only if his or her EU national spouse from whom they separated stops being a qualified person. In other words, when they stop working or stop being self-sufficient or self-employed in the UK. But this is not what the case scenario number 4 is about. It is about 3 categories. Number 1, it's about couples who officially terminated their marriage. The relationship is considered to have been terminated with a decree absolute, decree nullity, or certificate of dissolution. This is for civil partners. So if they have one of the above documents, they can claim that they have retained their right of residence provided their EU national former spouse was a qualified person, and in the majority of cases that will be a worker, self-employed or self-sufficient person on the date of the termination of their marriage or civil partnership. And the non-EU national former spouse, the applicant in our case, was residing legally in the country, in the UK, on the date of the termination of their marriage or civil partnership, and the non-EU national former spouse is now a worker or self-employed or self-sufficient person. In other words, they are financially independent and they will not be relying on public funds if their application is allowed. In addition to above 3 requirements, the non-EU national former spouse will need to prove one of the following. That the couple has been married or in a civil partnership with an EU national for at least 3 years immediately before beginning the proceedings for the divorce, and the couple lived in the UK for at least 1 year. B is for if the above requirements are not satisfied, not to worry, because you can still satisfy this and claim that you have retained right of residence if you can prove that you have custody of an EU national child. And C, if you do not have the custody of the EU national child, you can still qualify if you have a right of access to that child, provided the child is under the age of 18. And the court has ordered that such access must take place in the UK. And D is for if none of the above applies to you, you can still qualify if you can prove that you were a victim of domestic violence. So there is no qualifying period for victims of domestic violence, and you do not have to have children in order to benefit from the provisions for victims of domestic violence. Now, let me give you some examples so that you're very clear about this rule. We have Danica, an Indian national. She married Patrick 5 years ago. Patrick is a French national, and Patrick and Danica both work at a local IT company in London, UK. After residing together for, let's say, 2 years in the UK, they decided to separate. Will Danica have any rights to remain in the UK? The answer is yes, because the couple only separated and they haven't officially divorced. So in practice, Danica's rights will remain exactly the same as before. So she will have a right to remain in the UK for as long as Patrick continues working in the UK. So before their divorce, her rights will be attached to his. Now, let us say that Danica now divorces Patrick, and when they officially divorce, both Danica and Patrick continue living and working in the UK. Will she have any rights of residence in the UK after she receives her decree absolute document? The answer is quite likely to be yes, because she meets all the necessary requirements. Number one, they are officially divorced, and they have a decree absolute to confirm this. Number two, Patrick was a worker on the date when their marriage terminated. He was working in the UK. Danica is also was a worker, and she will be working at the time when she makes her application. Their marriage lasted for at least 3 years. Well, in our case, they were married to each other for 5 years. And number five, the couple lived together for at least 1 year before initiating divorce proceedings. And from our case scenario, we know that they have been living together in the UK for 2 years. For our next example, let's assume that Danica arrived in the UK together with her and Patrick's 1-year-old son, Leon, and decided to divorce Patrick only 3 months after her arrival to the UK. So in this example, she will not be living with Patrick for at least 12 months. So she will still qualify, provided she has the custody or the rights of access to Leon, their child. And the court has decided that this right of access to Leon should be exercised in the UK. The only one additional thing she has to prove here is that she is either a worker, self-employed, or self-sufficient person. What is Danica let's say, what if Danica and Patrick do not have any children, and Danica divorces Patrick only after 3 months of their marriage because she became a victim of domestic violence? Will she still qualify? The answer again in this case scenario is likely to be yes, provided Danica can prove that she's a worker, self-employed, or self-sufficient when she applies. And remember, with domestic violence cases, it is completely irrelevant how long your marriage lasted for, as well as your length of residence in the UK. Due to Brexit situation and the uncertainty surrounding rights of EU nationals and their family members in the UK, permanent residence application forms topic became particularly relevant. I've noticed that some of you are completely lost in this 85-page form full of legal terms spread across the 19 sections. And therefore, I've created a free expert secrets guide on how to complete this permanent residence EEA PR form. And you can now claim your own free copy at bit.ly/free guide on EEA PR form. This offer is very limited though, so don't be left behind and claim your copy today. Please give thumbs up, subscribe, and share this information with those who may benefit from it. Thank you so much for watching, and have a great day.